Hello everyone, welcome back to our daily issue analysis Dia. And I'm glad that it's helping you all and we are getting very encouraging messages. So keep revising the notes, handwritten notes which we are providing on our Telegram channel. So if you have not yet joined, please join it so that you can access those you can have access of those handwritten notes. And okay, so let's start learning for the day. So today we have chosen this topic of electoral reforms and especially the increasing criminalization of politics. So why it was in news? It was in news because Supreme Court has raised a concern on Thursday. They have raised a concern over the increasing incidences of criminalization in politics. So if you analyze the data from 2014 to 2019, we can see the increase. So in 2014, 34% of MPs were having pending criminal cases, and in 2019 43% MPs are there with pending criminal cases, and this is the concern. So, as you can see, no, what Justice Nariman is saying, no political party offers an explanation as to why candidates with pending criminal cases are selected as candidates. So, what happened in directions which were issued by Supreme Court in a judgment in 2020? It told that it is mandatory. Just read the words written in red color. It is mandatory for all the political parties to publish the details regarding pending criminal cases against their chosen candidates, and they need to display those details regarding the pending criminal cases about the candidates on party website and social media handles. Okay, so this was a direction given that it is a mandatory and you have to publish it on the website and social media. And also the parties, they need to tell about the reasons for such selection, why you are selecting such people, why you are selecting candidates with this background. It is very important, you need to tell the reasons. And not only that, the reason should include the qualification, achievements, and merits, and not merely you should not merely tell that winnability at the polls. You tell about qualification. The parties should tell about the qualification, achievements, and merits of the candidates. So this was a direction issued by Supreme Court. But yes, we know that how far it is being implemented or is being followed. So keeping that in mind, we are discussing about criminalization of politics. So let's see next. Whenever we are talking about criminalization of politics, definitely we cannot miss about muscle power. Whenever we talk about muscle power, so Law Commission report has recommended that Section 4A should be inserted in a new section, should be inserted in RPA Act 1951. Why? The purpose is that they must declare the assets and the criminal cases. It should be mandatory for them even if it is pending against a candidate. So criminal cases pending against a candidate should be declared, and that should be made necessary qualification for joining the to get the house membership. So this is what a law commission report is advising, suggesting. Next, even election commission report is suggesting that with respect to the proposal to disqualify a person, what is the provision? Provision is that section 8 says that a candidate who is convicted for a crime should be only disqualified. Okay, but election commission report which was proposed in 2004, it says that under section 8 it should be amended and the candidate should be disqualified. There is a proposal to disqualify the purpose even during trial time. Okay, because by the time the person gets convicted, they will even fulfill their tenure. For example, while I'm making this video, there is a news floating on my mobile that Raj Babbar has been convicted, or he has been given a punishment of 2 years imprisonment in some case related which happened 26 years back. Now think about judiciary. So I was going through the comment. So it is written that for everybody else, whosoever is working in whatsoever field, for everybody there is a time limit. In a time bound manner, you have to work. Only for Indian judiciary, there is no time limit. So whatever has happened 26 years back, now they are saying that okay, Raj Babbar should be sent for 2 years in jail for 2 years related to some case of that time elections. So this is the status. So election commission report is mentioning that the candidate should be disqualified even during trial. However, there are concerns. Some people are saying that maybe the rival parties or the ruling parties, they will use it as a tool. But For that, what's election commission is recommending? Election commission recommended that, okay, in that case, cases filed prior to 6 months before the election should would only lead to disqualification of a candidate. So they are suggesting, they are projecting solution as well. So this is about how to put a check on muscle power. Next is, even election commission, or for that matter law commission, they in both have recommended that a negative or neutral voting option should be created. And the purpose is that it will allow voters to reject all the candidates on the ballot by selecting this nota, none of the above option, instead of a name of a candidate on the ballot. However, in this has been brought, now we have nota in place, but not much voters are aware of it. So we need to make nota effective. So that is what is required. So now we have nota, but effectiveness is not there. So we need to make it more effective. Let's discuss other issues related to other reforms. We have seen about criminalization of politics, muscle power, what all reform should be there. We have seen the status, so we have now data. You need to present that data maybe in a graphical format. If you can present, it will be very good. We have discussed that why Supreme Court is talking about and what they have recommended, and the other reforms suggested by Election Commission and Law Commission. Now, with respect to money power, when it comes money power is also a very big problem, and it is a matter of concern for electoral reform. So, according to ADR, 55,000 crore rupees was spent in 17th Lok Sabha election, which is more than American presidential election. And when if somebody, if let's say our political parties, the candidates are spending these much, then definitely they will try to cover up that money. And the report also says that, ADR report says that 475 parliamentarians, that is around 88% out of 53, 533, they are crore-patis also. But however, that is not the matter of concern. The matter of concern is that if campaign expenditure is rupees 55,000 crore, then definitely that money will lead to, that expenditure will lead to compulsion for corruption. So even this was highlighted by National Commission to review the working of the constitution in 2001. They told that the high cost of elections, it creates a high degree of compulsion for corruption. So you read about National Commission to review the working of constitution, Venkat Chalaya in your polity book, Lakshmikant. So there also this issue has been highlighted that if the cost of election is increasing, then it will lead to compulsion for corruption. Okay, and if compulsion for corruption is there, then definitely the sources of some of the election funds will be unaccounted, and there comes the role of criminal money, money which is unaccounted, and that too unaccounted criminal money in return for this compulsion to fill this gap. So what all can be done? So there are recommendations which has been given, and the recommendations include that there has should be a mechanism for routine verification and auditing should be done. And not only that, this auditing and verification is related to the return of the expenditure. Whatever return is being filed by the candidate, that return of the expenditure should be verified and audited. Also, publicity of those returns in local press should be done. So whatever returns has been filed by the candidates, it should be published in the local press so that transparency will be there. So are you understanding that all these steps are going to push transparency? They are going to push accountability. So that's why it has been recommended. Also, NCRWC, that is National Commission to Review the Working Committee working of the Constitution, it recommended that the particulars of assets and liabilities should be audited by special authorities. Okay, so that for the both, for the candidates and the political parties, should be audited by a special authority. So it will it will again push for, it will be a push for transparency. And also it recommended that candidates should submit audited statement of expenses at the end of election. Each candidate should submit it under their respective heads. So again, it is a drive for transparency so that money power can be reduced and things will be transparent. Election Commission, the next point is that Election Commission recommended that there should be amendment under section 125A of RPA 1951. The purpose of this amendment is to give more stringent punishment for candidates and parties who are concealing or providing wrong information on the form. So they suggested that 2 years of imprisonment should be there for concealing and providing wrong information. This is a report. This is the recommendation by Election Commission. Also, we all know about second ARC. So second ARC, the reports which were submitted under Virappa Moli in 2009, there is a report on ethics in governance. So that report says that a system of partial state funding should be there. Partial state funding of election should be introduced in order to reduce the scope of illegitimate or unnecessary funding of expenditure for election, so that there will be limited amount and legitimate amount will be there. So unnecessary or illegitimate funding of expenditure for election will not happen. In fact, this recommendation was also given by Indrajit Gupta committee. So they also recommended it. Next, Election Commission of India also recommended that there should be ceiling on expenditure, and thus it will lead to rationalize the expenditure from time to time. So in order to put a ceiling, we should rationalize the expenditure from time to time, because every time will have its own inflation, every time will have its own commitment. So we need to rationalize, and thus we need to put a ceiling accordingly. So this is also a recommendation with respect to how to put a check on money power. Also, Supreme Court of India in a judgment in 2003, in a judgment is about People's Union for Civil Liberty, that is PUCL, versus Union of India. So maybe in short form you can say PUCL. It recommended that candidates who are fighting or who are uh, uh, who are there for electoral office must submit the affidavits of what? Candidates must submit affidavits where they are disclosing their assets and liabilities. So the candidates must submit an affidavit disclosing their assets and liabilities. So this is the recommendation by Supreme Court in 2003. So these are the steps which has been recommended time to time by second ARC, Election Commission, Supreme Court, NCRWC, about how to put a check on the money power. And now we have data with respect to the campaign, that is 17th Election Commission, 17th Lok Sabha elections. The according to ADR, the campaign expenditure was rupees 55,000 crore. So now we have data, we have gravity of the problem, that how it is leading to criminal money, and thus we have recommendations accordingly. Let's look at other electoral reforms. Whenever we talk about the electoral reforms, then we cannot miss and we should not miss about the provisions where we are talking about strengthening of the Election Commission of India. So under Article 324, we have provision of Chief Election Commissioner, we have provision for the appointment of Election Commissioner, but the clause 5 of Article 324 does not provide similar protection to Election Commissioner as it is provided to Chief Election Commissioner for removal from his office. Okay, if we talk about the removal of Chief Election Commissioner, it says that the Chief Election Commissioner shall not be removed from his office except in like manner and on like grounds as Judge of Supreme Court. So remember this, from his office except in like manner and on like grounds as Judge of Supreme Court. But this provision is not available for the election commissioners, and it only says that they can be removed from office except on the recommendation of Chief Election Commissioner. So there is no safeguard. So it is recommended that amendment should be brought to provide the very same protection and safeguard to election commissioners as well. Also, the election commission also recommends that we have a secretariat of the election commission, which also consists of officers and staff at the various levels. So election commission has recommended that they should be insulated from the interference of the executives in the matter of their appointment or promotion, right? So there should be no interference. So the role of secretariat should be independent. If we are appointing and the executive is interfering in that, then it will dilute the independence, it will dilute the autonomy. Okay, so that is one recommendation is there by Election Commission. Also, the third recommendation is that election commission whatever budget it gets, it is treated, should be treated as charged on the consolidated fund of India. So this is one of the recommendation that election commission is that budget should be treated as charged from the election consolidated fund of India, that no voting and all is being done. Okay. Next is, there should be power with election commission to de-recognize or de-register political parties who are violating the model code of conduct. So for that also, under Representation of People Act 1951, sufficient power should be there with the election commission. As of now, election commission has no power to de-recognize the political party for any such violation. So that is also one of the recommendation or desired change which is there, which will strengthen the election commission. Next is the matter of paid news. So we know any news, be it print media, electronic media, which is there after paying a price, it is called as paid news. And this menace of paid news, it disrupts the level playing field, which uh, which is there related to election. Okay, it doesn't provide the level playing field to all the candidates. So this creates hurdle for Election Commission of India to conduct the overall election smoothly in free, fair, and transparent manner. So this is not an electoral offense now. For that, amendment is required. Next, next is statutory status to MCC should be given. Statutory backing to Model Code of Conduct should be given. Okay, so for now there is no statutory backing. If there will be statutory backing, then only Election Commission will have can exercise the power to enforce the Model Code of Conduct. For now, a lot of limitation is there. Okay. Next is related to post-retirement jobs. For now, there is no cooling off period. The election commissioner, whosoever is getting retired, so there is no cooling off period. So the recommendation is that there should be cooling off period at least of 5 years. The election commissioners should not be eligible for any office after their retirement, at least till 5 years. They should not be allowed even to join any political party for a further period of 5 years after retirement. Then only they will be able to uh, become neutral. Otherwise, we know that people have vested interest and how they will serve. Also, whenever we talk about the process of appointment, so the chief election commissioner, and for that matter, state election commissioners, they are appointed in a very, let's say, arbitrary manner. So the recommendation is that they should be appointed by multi-party committee. In fact, NCRWC also recommended that chief election commissioner and the other election commissioners should be appointed on the recommendation of a body consisting of prime minister, leader of opposition of Lok Sabha, leader of opposition of Rajya Sabha, speaker of Lok Sabha, deputy chairman of Rajya Sabha. So they also recommended it that it has to be transparent, fair, in a just manner, free from any ill will or any vested interest. So these are the reforms which are related to strengthening of the election commission. We will look at the other reforms, electoral reforms. Whenever we are talking about other reforms, electoral reforms, we should be also familiar with other reforms. Then only our answer will look more holistic in nature. So include the elements from the recent years. So for example, if we talk about electoral bonds which were introduced in 2017, so it has an anonymous feature in which neither the donor nor the political party is obliged to reveal whom the donation comes from. Also, we know that the State Bank of India is taking care of this. So that is a state-run entity. So anytime government at any point of time can look into the names of the anonymous donors. So that is not a big deal for them. So what is the purpose? The purpose of transparency has been defeated. If government itself is managing everything, so the purpose has been defeated. So interference might happen. So this is the issue which we should look into. Also, till date, the political parties, how they are working, we don't know. There is no transparency, there is no accountability. So transparency in working the style of the party should be brought. So that's why it has been recommended from many times that political parties need to be brought under the ambit of RTI Act. This will increase the transparency, the way they function or the funding or any aspect of it. Next is related to section 62(5) of RPA Act 1951. So this section is mentioning that anyone who is confined behind the bars, that is in prison, they cannot vote. So we know that in India, 75% of 75 or percent of the prisoners, they are under trial. Nearly, that is around 5 lakh prisoners. So they cannot come out and they cannot vote. However, we at the same time we also know that a person who has been convicted for criminal offense, or the trial is going on, sometimes they manage to get secure bail and can vote. So that is also, even if they are under trial, they have money, so they can come out because they can get bail. What about people, the marginalized people? Sometimes because of the some error they are behind bars, but they cannot come and vote. For that purpose only, in UK, only convicts sentenced to prison for 4 years or more cannot vote. So we also know our law, our criminal justice system itself says that anybody uh, is innocent till they are proven guilty. So how we can stop them from voting? So this section 62(5) should be amended, because it says that the person cannot vote because just because they are behind bars. So they are using this word confinement, they are not using conviction word. Okay, so this is another reform which should be there. Also related to freebies, we know that how freebies, they are disturbing, they are skewing free and fair election, they are interfering in free and fair elections, and thus they don't provide a level playing field between big parties and small parties. So money power comes into play, and not only that, if the ruling parties they are involved in this, so states fiscal health is getting disturbed. Sometimes it is causing the breach of FRBM targets. Okay, so freebies another issue. Also the use of social media, the role of social media should be regulated, because we know that a lot of controversy, the fake news, or the we are living in post truth era, so it needs to be regulated because a lot of advertisement or nudging is happening through social media. So that should be brought on same pedestal as the as we treat print media. So these are the other reforms which should be there. Now we will see certain other recommendations related to Supreme Court judgments, time to time what Supreme Court through judgments have told. Whenever we are talking about the reforms, then definitely we should not miss the important court judgments. So Supreme Court in various cases have recommended various reforms. So let's discuss them one by one. So the first case is ADR versus Union of India, that was in 2002. So here Supreme Court suggested that contesting candidates, they need to disclose their assets and liabilities, criminal convictions. So remember it, be it asset, be it liability, or criminal conviction, they must disclose it at the time of filing their nomination paper. So let's say if you are coming and you are filing your nomination paper, so you must disclose about your assets, liabilities, and criminal convictions. So which case is saying ADR versus Union of India 2002. Next is Ramesh Dalal versus Union of India. This is from 2005. So if you don't remember the verses also, versus Union of India, it is fine, don't worry about it. So here they recommended that a legislature is disqualified from contesting election if on the day of filing nomination paper he or she stands convicted in the court of law. So let's say if you're coming to file the nomination paper and you have been convicted by the court, then you will be disqualified. A legislature is disqualified from contesting the election. So this is under in Ramesh Dalal versus Union of India. Lily Thomas versus Union of India 2013. It is a very famous case. So here, the nature of disqualification was commented upon by the Supreme Court judgment. So they told that the nature of disqualification for being a member of the House as provided under Article, remember these article 101 and 190. Under that also subpart 3. So 101 and 190, if anyone is getting disqualified as a member of the house, so whatever is provided under that the provisions, it is automatic and takes place with immediate effect. So if the disqualification is happening under article 101 and 190, so it is immediate and with immediate effect, and it is automatic. So that was told by Supreme Court in Lily Thomas. Then we have PUCL, People's Union of Civil Liberties versus Union of India. This was in 2013. So here Supreme Court told that voters enjoy right to negative vote in election process, and it directed Election Commission of India to include this choice of NOTA in the ballot paper. So in 2013, I still remember when it came. I don't know what was it, but after reading, I felt that it's very empowering. You feel like, yeah, you have been empowered, you have been given this power, so maybe your fundamental right which you are exercising. I still remember when I was reading this article in 2013 when Supreme Court came up with this, it was like a breather, some fresh air. So that's how we as a citizen we feel empowered. So these are the important judgments which you should remember and use them in your answers. And whenever you're writing your conclusion, definitely it has to be futuristic, it has to be optimistic. So do write about clean polity, free and fair elections, vibrant democracy. You talk about how Election Commission of India is focusing on voter awareness. So we are celebrating January 25 as the National Voters Day. Also, we have SWEEP, that is Systematic Voter Education Electoral Campaign. Also, the focus should be on inclusivity, so and accessibility. So Election Commission is doing very good efforts, very good practices they are coming up with in order to make this whole electoral process accessible and to make it inclusive. uh, for example, polling booth was set up by Election Commission of India even in the Gir forest. For a single forest they set up the polling booth. So like this they are reaching out to remote areas, inaccessible areas. They are they are walking on foot and they are doing their best so that the whole electoral process becomes inclusive and accessible for all the citizens. So do write some way forward or conclusion where you are writing positive things, like everything is not dark and gloomy, so there are certain good things happening around, and yes, there are chances of improvement as well. So this is how you should sound in the conclusion. Hope you got a very good clarity and a quick revision of the electoral reforms which should be brought in and why it was in news and what all Supreme Court has told through different judgments and different like election commission, money, muscle power. So under different heads we have discussed the recommendations also of election commission, law commission, NCWRC, and Supreme Court judgments. Okay, so revise them, then only you will be able to reproduce them in the answers. So take care, guys. Have a good day. We'll meet tomorrow.